I was at a bar mitzvah last Shabbat in Manhattan, and at the close, the rabbi had a few remarks. And he said he'd asked the bar mitzvah earlier in the week, what do you think it's going to feel like when you're up on the bima leading the service? And he said that the bar mitzvah gave him an answer, which the rabbi then wove into a notion of you can't know what a moment in the future is going to feel like until you're actually in that moment in the future. And I was reminded by that as I heard the thank you to Baha'i International, which I join in extending, sheltering us from the cold, and in offering my thanks to B'nai B'rith for giving me the opportunity to speak today. There's a connection between all those things. I'm not sure what it is, but let me just throw out a couple facts. The center of Baha'i International, as I understand it, is in Haifa, where I was born. I'm the child of two survivors who emigrated to Israel after the war. And strangely enough, after being born in Israel, my family moved to Omaha, Nebraska, which has two connections to today. One, it's typically this cold in Omaha, Nebraska. As a matter of fact, this is considered probably pretty balmy for Omaha. But the second aspect of it, and perhaps a little more important, is that I believe one of the centers, one of the starting points, if not the starting point of B'nai B'rith, was in Omaha, Nebraska. And there is now a Phil Klutznick center not far from the senior center where my mother gets rehabilitation in Omaha to this day. It's a beautiful place. Another preliminary, by the way, I don't know what to make of all that, but I'm sure there's something. Another preliminary point is, as I was introduced, I do work for the Claims Conference, and the Claims Conference, as you may know, is the main negotiator, has been the main negotiator with Germany since 1950, having to do with various compensation programs that are Holocaust related, which the Claims Conference administers and Germany funds, and having to do with property restitution in what was formerly East Germany, which the Claims Conference has made claims upon, and when it succeeds in obtaining a property, it typically sells it and uses those proceeds for social welfare assistance for survivors in need around the world. You're going to hear me mention the World Jewish Restitution Organization in my talk. The Claims Conference, as is B'nai B'rith, is one of the constituent members of the World Jewish Restitution Organization, which was formed, I think, 1992-93 after the fall of communism, specifically to seek restitution in the former communist bloc countries. There must be something of an inner rabbi in me that compels me to start my remarks in the following way. In the first book of Kings, the prophet Elijah, who is probably best known for his highly anticipated visits late in the Seder during Passover, the prophet Elijah, confronting the government of his place and time, led by King Ahab and Queen Jezebel, demanded of the king, "Have you murdered and taken possession?" That encounter takes place after Ahab and Jezebel engineered the murder of Naboth, the owner of a vineyard near their palace. The royal couple wanted the vineyard. Naboth didn't want to give it up. They had him killed. After Ahab and Jezebel took possession, Elijah challenged the king, declaring it forbidden to benefit, to gain an advantage from criminal conduct, whether the king's or someone else's. It's not that the leaders of any of the countries in which restitution is sought for property wrongfully seized during World War II are responsible for the Holocaust. They're not. Yet, many of these governments have, with the passage of time and the absence of effective, or sometimes any, restitution laws, benefited from those crimes, because those crimes resulted in their possession of certain properties. The crimes of the Nazi murderers and robbers and their allies of decades ago have resulted in these countries inheriting, profiting from properties they continue to hold or properties they sold which did not belong to them, but belonged to, among others, Jewish victims. The next few minutes, I'm going to offer a short historical background and then a very general summary of the current situation with respect to the restitution of formerly Jewish-owned property, private and communal, in the former communist bloc countries. But it's always useful to keep in mind that in discussing restitution at this stage, while there are Holocaust survivors, and still many of them, that clearly need substantial assistance that could be obtained from returning to them what was rightfully theirs, the restitution undertaking at this point is truly about something more than money. It's mostly about justice. In addition to the attempted destruction of European Jewry, the objective, wherever Nazi influence reached, was similar: expropriate all Jewish property, whether owned by a group, by a community, or by an individual. And by the spring of 1943, there was almost no real property remaining in Jewish hands in occupied East Europe, where before the war, in nearly every city, town, and shtetl, there had been properties owned by Jewish communal and religious entities, to say nothing of individuals, that were an integral part of the vibrant Jewish life in those areas. Immediately after the war, Central and Eastern European countries failed, typically, to take significant action to restitute real property confiscated from the Jews and other Nazi victims during the Holocaust. Communist regimes had nationalized all the property by the end of the 1940s, so the very basis of property ownership in many countries had been shattered, preventing former property owners from recovering what was rightfully theirs. Generally speaking, apart from Germany, these regimes, from the end of World War II to 1990, never confronted the damage to the Jewish world, never considered the restitution of any property. Following the collapse of the Iron Curtain, 45 years after the end of World War II, efforts only then began by Jewish communities, together with certain Jewish groups, including the WJRO, the World Jewish Restitution Organization, to press former Soviet bloc countries to act, whether by enacting meaningful restitution legislation or establishing claims processes. The subtext of the mission was generally to bring increased attention to the issue of restitution. But it was a complex undertaking for a number of reasons. Circumstances in different countries varied greatly. Each country had a different historical experience. Each country was challenged by different economic circumstances, and each country was governed by a different legal system. In addition, records had been lost or destroyed, and data protection laws impeded the research of ownership records which did exist. Many former property owners no longer lived in their country of birth, the country where their property was located. They lived in foreign countries and had forgotten much critical information. And pursuing remedies in local foreign courts was burdensome and expensive. And finally, there was government and the local population's resistance, which was often reflected in a lack of political will. I don't know of a party in Eastern Europe or Central Europe whose platform includes in their platform, we're going to restitute the property of Nazi victims. But in spite of all these obstacles, after the demise of the communist regimes, there have been some positive steps taken relating to the restitution of property, private and communal, seized from the Jews. But the progress has been painfully slow. Almost 7 decades after the end of World War II, over 2 decades after the fall of the Iron Curtain, much of the property seized during the Holocaust era remains in the hands of governments at various levels or individuals in the local populations, and they're protected by the prevailing or the absence of pertinent national laws. So I want to give a quick survey of the lay of the restitutional land. And for me, it's useful to use a device which separates countries according to where they are in terms of restitution laws. It's a rough measure, but it helps me kind of categorize countries. And what I talk about in this way is about the legislative or the moral clarity of a country, the legislative or the moral ambiguity, or the legislative absence or moral hypocrisy of countries. By saying legislative or moral this or that, I don't mean to say that laws reflect morality. They often don't. But what I do mean to say is that to the extent legislation, laws in a country, in some way address the history of what happened in that country in the Holocaust, I find that to be a moral component. So what I mean by legislative or moral clarity is that a country has passed restitution laws. The laws deal with property confiscated during the Holocaust, and there are remedies that either deal with the restitution, that is the return of those properties, or providing fair and reasonable compensation for those properties when they can't be returned. What I mean by legislative or moral ambiguity is that a country has passed a restitution type law, but there are significant problems with it. Either the law doesn't deal with property confiscated during the Holocaust, it deals with property taken, nationalized when the communist regimes governed. Or it doesn't provide for the restitution or the return of the property. Or it has discriminatory conditions where you have to still be a citizen of the country to make a claim for property that is in that country. Or it provides compensation, but it's minimal, symbolic. And then there's the category of legislative absence, that is no law, which I also term moral hypocrisy. And I use that term, one, to get attention, but also because I feel for a purported democracy not to respect property rights and not to respect the rule of law, which I think is the case when they don't deal with property that was stolen during the Holocaust, is moral hypocrisy when they claim to be a democracy. So let me give a couple examples. Poland, home to the largest Jewish population in Europe before the war, stands at one end of the spectrum. It has been conspicuous in failing to enact any law regarding the return of or compensation for private property located in Poland that was seized during the Holocaust. Since 1990, Polish governments have made commitment after commitment and proposed numerous draft laws, none have been enacted, to deal with the restitution of confiscated private property. Then in the spring of 2012, after some 12 years of having failed repeatedly to pass a restitution or related compensation law, notwithstanding its recurrent commitment to pass such a law, the Polish government shifted tactics. At that point, the government insisted that claimants wrongfully deprived of property should pursue their remedy in Polish courts. Of course, that option had been open and overwhelmingly ignored or deliberately rejected by claimants for years, and for good reason. The legal system in Poland is procedurally complex, as well as expensive and time-consuming. Moreover, in the end, a claimant can't sue directly in Poland for the return of property seized during the Holocaust. Instead, a claimant has to establish that his or her property was seized in violation of a pertinent, albeit admittedly unjust, communist nationalization law. So it's unlikely that the litigation suggested by the Polish government will bring interested parties anything more than additional frustration and resentment. So I call that legislative absence, or if you will, moral hypocrisy. A government that purports to be democratic, that is indeed a good friend of Israel, it's a mixed bag, nonetheless has not really faced what happened in the country in terms of the seizure and confiscation of property during the Holocaust. In the middle of the restitution spectrum, there are a number of countries with restitution laws, such as Croatia, Romania, Hungary, Lithuania, Serbia, I'm not going to go over them all, where there has been some progress, but for one reason or another, these laws have really achieved little for former Jewish property owners and for the Jewish community. For example, Croatia's law requires a claimant to be a current citizen of the country or a citizen of a country that has a bilateral treaty with Croatia. There have been recent efforts to eliminate that condition, and Dan and I have been involved with some of that, but none of those recent efforts have succeeded. So you still have to be a current citizen of Croatia or a citizen of a country with a bilateral treaty. But even if that were changed, and a foreign citizen could sue in Croatia, it wouldn't help most former Jewish property owners, because the prevailing law in Croatia only covers property that was seized after 1945. Again, after the communist regime took over. It does not cover property seized during the Holocaust. There are a couple of other issues with Croatia, like that also are the case in a lot of the countries in former Yugoslavia. There's something called Tito's Law. A number of people, Jews in particular, before leaving those countries after the war and wanting to immigrate to Israel, had to specifically denounce their citizenship and denounce any property rights they had before being allowed to leave. That still is the case. They can't claim former property. So Croatia is one example of a country with a law, but still problematic. Romania is another country with a restitution law. As a matter of fact, it has lots of restitution laws. But, unlike the Croatian law, the Romanian law appears beneficial in language, in theory. But unfortunately, when implemented, the restitution process in Croatia is profoundly flawed. There are overlapping rights and procedures, frequent and lengthy delays in rulings, and much confusion as to what decisions actually mean when they're given. There are also serious problems with respect to payments. So serious are the problems related to the remedies for property restitution in Romania that the European Court of Human Rights in Strasbourg, France, frequently rules against Romania in property restitution cases, repeatedly criticizing the government for the exceedingly slow process and ineffective, virtually paralyzed payment mechanism. Ultimately, the European Court of Human Rights gave Romania a time limit within which to undertake all necessary measures, whether legislative, administrative, or budgetary, to deal with the protracted delays in returning seized property and to provide timely and fair compensation, or to face court sanctions. There are other cases, like Lithuania, which has recently taken a step in the right direction and passed a law giving compensation for communal property. But the compensation is only a fraction of the value of the property that was taken. And there is Serbia, which also recently passed a property restitution law for individuals. But the law doesn't cover, again, property that was seized in the Holocaust. It simply deals with communist nationalizations. So those are the middle range cases. What I call legislative or moral ambiguity. There is a law, but there are difficult issues with it that really don't provide all that much, certainly for Jewish individuals in the Jewish community. Finally, at the other end of the spectrum is Germany, which understandably has implemented the most far-reaching restitution and related compensation laws, as well as, by the way, individual compensation programs for victims of Nazi persecution. The Federal Republic of Germany, soon after the Allied occupation of the country ended, issued laws dealing with the return of property confiscated during the Holocaust. Moreover, once the Berlin Wall fell and the two Germanys were joined, as part of the reunification agreement, a commitment was made and implemented regarding what was formerly East Germany. Specifically, restitution regarding East Germany involved the return of property taken or related compensation given to former property owners or heirs of owners. Germany also serves as a model for dealing with heirless Jewish property, an issue that's avoided by pretty much every Central and Eastern European country. I mentioned I work for the Claims Conference. The Claims Conference has been the main negotiator with Germany for property located in East Germany, which is heirless. And as I said, that heirless property, which once the Claims Conference shows that it is heirless, shows that it was Jewish owned, is sold, the proceeds of which are used for social welfare programs for survivors in need around the world. I just want to mention the European Shoah Legacy Institute, again, which B'nai B'rith, the Claims Conference, and WGERO have been involved in, is planning to have yet a conference this summer, currently tentatively scheduled for June, that is going to deal with social welfare. And I think one of the aspects that will be raised is trying to approach East and Central European countries with the notion of using the heirless Jewish property they hold to create funds to provide assistance to needy survivors in their country, home care and other types of emergency care. That's my view. That's not necessarily the view of the Eastern Central European countries. Whatever the complexities or fragile states of economies that have inhibited restitution, it is troubling to realize that as of this late date, the following general circumstances still prevail. A substantial amount of formerly Jewish-owned property, private and communal, wrongfully taken during the Holocaust, has not been given back, nor has compensation been paid for it. The compensation which has been paid to former Jewish property owners in lieu of restitution has typically been, by any reasonable standard, symbolic or minimal. And most East and Central European countries have not addressed the issue of heirless Jewish property, which is heirless not because individuals passed away naturally, but because of the systematic murder of former Jewish owners and their families during the Holocaust. Truly, lamentably, from crimes committed years ago, current governments, even if unintentionally, continue in possession of the fruits of those crimes and continue to profit from them. There were crimes and murders committed, and they have taken possession. Much remains to be done.